Well, hello there. How's it going? It's good to see you, and welcome back to another installment of Closing Arguments. I am your host and moderator, Ryan Ruff, and as always, we have the star of our show, Mr. John Razumich, or many know him by Jack, joining us from Razumich Associates to dive into another criminal law-related discussion. That's what we tackle here on the show. We lean into Jack's experiences from inside and outside the courtroom, and we're tackling a different criminal law-related topic each time we get together on this show. And today we got a good one dialed up for you guys. Today, if you caught our last episode, we took a nice little dive into these different legal myths that exist. We got some great feedback from you guys, our audience, our viewers, on different myths that you've just heard, whether it was through conversation with friends and family or saw online. That we put a lot of myths to bed in our last episode, but today we're going to take a little bit of a different angle towards another criminal law related discussion. Today, what we're doing is we're identifying affirmative defenses in Indiana. Now, many of you who are frequent, viewers and listeners of the show, that Jack practice and Jack and Razumich and Associates as a whole practice criminal law cases not only throughout the greater Indianapolis area, but also the greater state of Indiana. So we're diving into different affirmative defenses that exist throughout Indiana. But let's go ahead and bring Jack on now and let's get right into this topic. And let's start at that high level overview on really what an affirmative defense is. Jack, good to see you. Welcome aboard today.
Hey, Ryan, good to be back as always.
Yeah, no, always a good time when we get together. And I'm excited about today's topic. I know you've probably got a lot to unpack for us here in this idea of affirmative defenses in Indiana. I'm sure you're familiar with these on a very high level. So let's just set the scene, if we will, for our audience. When we say an affirmative defense, what are we talking about here?
An affirmative defense is a type of pleading that you would make as a defendant in a criminal case that argues that you are not responsible for the charged conduct. As a practical matter, the general policy is as a defendant in a criminal action, you're not required to prove or explain anything. It's always the prosecution's burden of proof beyond reasonable doubt to actually establish two very important things. The first is that a crime actually happened. And then second, that the defendant who's on trial for that crime actually committed the crime. What an affirmative defense does is it kind of throws a bit of a monkey wrench into that schedule, because what you're doing when you are making an affirmative defense is you're admitting that you actually committed the act that you're on trial for, but you had some sort of legally justifiable reason for it, some sort of legal excuse that makes it not a crime. That's what an affirmative defense is. You're not denying that you did what you're on trial for. You're just basically saying, this is why I'm not actually legally guilty of it, even though I did it.
Gotcha. And that's, we're going to cover a lot of different types of affirmative defenses that you've seen in your time. But as we're still kind of staying high level here, Jack, talk to us a little bit about this idea of where, the burden then shifts from, between the state and the defendant once an affirmative defense is out there and open and in front of everybody in a given case.
Sure. The dynamic changes. Again, like I said, when you throw an affirmative defense out there, you're throwing a monkey wrench. You're admitting, yes, I in fact did this. So that changes what does or doesn't need to be proved beyond a reasonable doubt for the most part. Since you're admitting that you committed the act, what the state's burden to prove at that point in time shifts from proving that the act actually happened. It shifts to proving that the affirmative defense is not applicable. There are a couple of instances where the burden is actually shifted from the state to the defendant to prove their affirmative defense by what's referred to as preponderance of the evidence. Laws, the burden of proof, there are three major burdens of proof in the state of Indiana. There's preponderance of the evidence, there's clear and convincing evidence, and there's proof beyond a reasonable doubt. Criminal trials, by and large, they are at that proof beyond a reasonable doubt situation. That's the general burden of proof the prosecution needs to meet to actually get their conviction. If you're making an affirmative defense, and it's up to the state's responsibility to disprove the affirmative defense beyond a reasonable doubt. That'll be for things like self-defense or mistake of fact or duress. We'll get into those into the next section. But there are a couple of affirmative defenses that actually require the defendant to prove something. Now, the defendant only has to prove those affirmative defenses by preponderance of the evidence, which is that lower standard. The way that is typically described is preponderance of the evidence, for the most part, If you think of it as being 50% plus one more likely than not, that's what your proof by preponderance of the evidence is. So if you're able to get one of those affirmative defenses that does require the defendant to prove the defense, that seems a little bit daunting because again, you shouldn't really feel like you have to prove, excuse me, you shouldn't feel like you have to prove anything.
Hmm.
But if it's a situation where your burden of production, your burden of proof is 50% plus one more likely than not, that's actually a really powerful tool that you have as a defendant that makes that a little bit more of a palatable concept to pursue those types of affirmative defenses.
Sure, sure. A really interesting topic here because there are so many variations and types of affirmative defenses, and then obviously every all the different inner workings and facets of a given case. Sure, they factor into what that affirmative defense type is going to be. So let's start kind of rattling off what some of these types of affirmative defenses are, Jack. And if you have any experiences with any of these particular ones, we'd love to hear them. So start high level with us, and we'll work granular. What's the first type of affirmative defense that you typically find?
Indiana recognizes a total of 10 different affirmative defenses. Nine of those are what are referred to as statutory affirmative defenses. That means that the state legislature has specifically listed nine defenses that are available to you as a defendant in a criminal prosecution. The nine statutory affirmative defenses are legal authority, self defense, involuntary intoxication, insanity, mistake of fact, duress, entrapment, abandonment, and battered spouse syndrome. Battered spouse syndrome isn't actually referred to as battered spouse syndrome in the Indiana Code. It's mental disease or defect as a result of abuse. It's effectively the battered spouse syndrome defense. Those nine are actually laid out in the Indiana Code as being statutory defenses that you can affirmatively plead and argue absolves you of any legal culpability. The 10th affirmative defense that's recognized by Indiana law is the defense of necessity. Necessity is considered to be a common law defense. That means that it predates the concept of statutory law. We just always understood that sometimes things are necessary. So that is a defense that's available to you. It still has some very formal pleadings that need to go along with it and some very formal ways that you need to dress that up and present that. But it is a creation of the courts. It's a creation of the common law. It is a recognized defense. It's just not statutory. It's kind of one of those things like everyone knows that we have the defense of necessity, so we didn't need to
Hmm.
write it down specifically.
Sure, got it, got it. Well, I appreciate you kind of giving us that lay of the land, the 10 that are really existing today. Let's start right at the top and let's work our way through these different types and where they pop up with different cases. Let's start with legal authority. Walk us through this one.
Legal authority is basically the argument that your actions would not be a crime if you had legal authority to do it. The most common way that you'll usually see this, and this is where I've used this defense in the past, is on the issue of parents disciplining their children. Um, Spanking and corporal punishment tends to continue to be a hot button topic. There are a lot of people out there who, in their opinion, don't believe that there's ever any reason to discipline a child with physical force or physical means. It is still legally recognized as an authority that parents have in the state of Indiana. So, a battery on a minor charge, for example, which would be knowingly or intentionally touching a person under the age of 14 in a rude, insolent, or angry manner, that would normally be a crime. However, if you have the legal authority as a parent or a guardian or someone who is acting in what's referred to as in parento locus, which is a fancy Latin term that basically means you are the stand-in parent at this point in time, you have the legal authority to exercise physical discipline on your children if you believe that to be appropriate or if you believe that to be necessary. So, under those circumstances, that's the type of situation where legal authority does exist for a defense of battery on a minor. You can make the argument that I have this legal permission to discipline this child. So, therefore, it's a crime for you to hit my kid. But if I hit my kid, it's okay. There are limits to that, obviously. Your ability as a parent to engage in corporal punishment or physical restraints of your children, there are limits. It does have to be proportional. You can't just take a whip and or a belt and flay your kids back or leave them with permanent injuries or permanent scarring. Uh, but most incidences of battery on a minor, if it is your child, you do get to claim the defense of legal authority, and that prevents that from being a crime. Legal authority is one of those burdens that the state has to disprove beyond a reasonable doubt. So again, you have admitted that you've committed the act, in this case, the Battery Act. And what that does at that point in time is the state's burden now has to be to prove beyond reasonable doubt that you did not have the legal authority to engage in that type of discipline or that type of criminal act.
Mhm.
I'm not. I'm sure there are other examples out there. I can't think of any.
Mhm.
But legal authority we typically find in the context, and that's certainly where I've used it in the past, in the context of a parent who's accused of over disciplining their child. That's the
Mhm.
most common place where you would find that defense.
Sure, sure, and that's an example I think that so many people are familiar with. Just a
Right.
pretty universal example there for us, Jack. So appreciate that. Let's move to our next one, and this one I know is a little bit loaded. We spent a whole lot, really a whole episode of this show diving into self defense cases as a whole. The next type of affirmative defense, self defense. Walk us through this one.
Self-defense, as you pointed out, Ryan, we did in fact do an entire hour-long episode on
Yes.
this. If you have not seen or heard that episode, I do encourage you to go back and listen to it. It'll be a lot more involved than what we're going into right now. Maybe just listen to it. Some of the earlier episodes, our audio, our video quality was not up to snuff, but it does listen really well. So I do encourage you to like, subscribe, listen, all that fun jazz. That said, self-defense is a statutory defense. What is involved in a self-defense pleading is, again, you are not denying that you committed whatever the act is, whether that act of force was taking another person's life or simply hitting them or touching them in some way, shape, or form. Self-defense is arguing that you had a reasonable fear of the use of imminent force on your person or on a third party, and as a result, you were acting in defense of them by using a proportional amount of force. That's a really big tongue twister situation. The short version of it, to try to explain it in the simplest way possible, is if you or a third party is about to be the victim of force, if someone is potentially attacking you or appears to be about to attack you, you are authorized under Indiana law to use a reasonable amount of force to repel that attack on yourself or on a third person. The force has to be proportional. If someone is swinging at you with a fist, you can't probably take a gun out and just shoot them, because that is a disproportionate result and a disproportionate use of force. If, however, a person is swinging a knife at you at that point in time, it would be considered potentially reasonable to shoot them, because a knife is a deadly weapon, whereas a fist, maybe not, depending on a lot of other circumstances. The rules with self-defense are, it's another one of those situations where the state has the burden to prove beyond a reasonable doubt that you were using more force than necessary to repel the attack, or that the use of force was objectively unreasonable. The very complicated thing you run into with the self-defense claim is the jury has to view the claim of self-defense from the perspective of the defendant under the circumstances that existed. If you think about a jury as a Monday morning quarterback, the idea is that the jurors have to put themselves in the shoes of the defendant claiming self-defense, who has to convince them that the use of force was reasonable under the totality of the circumstances. The belief and the use of force has to be objectively reasonable from the defendant's subjective perspective. Um, Honestly, we did go into this in a lot of greater detail in the episode earlier. It might have been like the fourth or fifth episode. Go back and listen to that. It's a much bigger discussion. It's a lot more involved. We kind of really did dive into that and dissect that a lot better. But for the purposes of today's episode, that's your kind of quick overview on the issue of self-defense.
Whoops, I was muted. My mistake. I'll just take it from here. Perfect. Well, Jack, our next one is kind of an interesting one. This idea of involuntary intoxication. Probably a phrase that many of us haven't really heard out there, involuntary intoxication. But walk me through what this means and how this can play out as an affirmative defense.
Involuntary intoxication, this is the first defense that shifts the burden to the defendant.
Okay.
Involuntary intoxication, if you plead involuntary intoxication, it is your responsibility as the defendant to prove by preponderance of the evidence that your state of intoxication is a result of an involuntary situation. Intoxicated is a legal state of being and has a specific definition. In Indiana, it means under the influence of drugs, alcohol, a controlled substance, or I think 5 or 6 other things they have on the list these days, that results in a loss, an impairment of thought and action, and a loss of your normal motor faculties. Most intoxication, of course, is very voluntary.
Hmm.
If you go out to a bar and you drink yourself into a blackout state, you're not going to be able to make the argument that you were involuntarily intoxicated.
Sure.
You were taking product that you knew could cause an intoxicating effect. Where involuntary intoxication can come up, and we actually just had a trial where this was an issue. It did not go well. It was at least a novel defense. The judge and the prosecutor were both fascinated by our efforts at arguing involuntary intoxication. What happened is that particular case involved a defendant who had a bacterial strain in his intestinal lining that created a situation referred to as autobrewery syndrome. The idea is that much like how a diabetic needs insulin shots to regulate their blood sugar content, the idea behind autobrewery syndrome is that the bacteria and the flora in your stomach and your intestines, as they're breaking down carbohydrates, as they're breaking down sugars, can effectively create a fermentation in your stomach that creates alcohol. That's a byproduct of breaking down
Wow.
sugars and carbohydrates. Our argument was in this particular case was that our defendant was not voluntarily intoxicated because he had a medical condition that rendered him that was unknown to him at the time, that effectively rendered him into an intoxicated state. And that is why he was operating a vehicle while intoxicated, because that involuntary chemical effect inside of his body. Part of the problem that we had with that case is it was a true and accurate fact that prior to this discovery that he had this stomach issue, he did in fact actually consume a beer. It was one of those rare things. We were able to track it down. We found his receipts. We found the waitresses that served him, and he quite literally did have one beer. It was one of the first times that someone actually just had one beer. The problem is you have to have clean hands for involuntary intoxication.
Mm,
If it had been a situation where, he went to Bob Evans and ate a
yeah.
stack of pancakes, there's no alcohol there.
Sure.
But
Sure.
the breakdown of the carbohydrates, if it caused that effect, he would be able to claim, okay, well, I consumed something that
Hmm.
was, non-alcoholic, not likely to produce this result.
Hmm.
My hands are clean on this.
And have the
Owing
receipts to prove it.
and he had the receipts to prove it.
Right. Right.
Um, Under this circumstance, in this particular case, what ended up happening is because he did consume a product that he knew was going to cause intoxication, the fact that it created a hyper intoxication was not going to be
Okay.
a defense on the involuntary intoxication
Mm,
situation. So you
makes
do have to
sense.
have clean hands for it. But it was an interesting argument.
Yeah.
It's one of
Yeah.
the very few
Absolutely.
circumstances that I've seen where involuntary intoxication might have worked.
Hmm.
And the way that went is, we had to file the involuntary intoxication defense, and it became our burden of production by preponderance of the evidence, that 50% plus one,
Right.
to show that the intoxication was involuntary.
Hmm.
Again, the state showed that
Yeah.
he had actually consumed alcohol beforehand, and that kind of negated that.
Sure.
Um,
Sure.
it's pretty rare.
Hmm.
We have had more than our fair share of cases over the last 16 years where people have said, well, they just kept giving me alcohol over and over again, or I don't remember drinking that much. Someone must have
Sure.
slipped me a
Sure.
roofie. It's like, I'm pretty sure you probably just had that much to drink. You can't claim that you started drinking and then
Yeah.
try to claim involuntary intoxication. You need
Especially
to,
in that case, the one beer is
yeah,
what was his downfall.
exactly.
So no, that's a great example. I appreciate you sharing that case with us. I'm gonna now flip the script on this one and move to the next one here, and that's probably a little more involved, I would imagine, and that's the affirmative defense of insanity. Walk us through this because boy, is this one that we see played out in so many TV shows and movies and whatnot. Insanity is such a hot topic in a courtroom. I feel like it gets a
Mhm.
lot of eyeballs. Walk us through this one, Jack.
Insanity is again one of those defenses like self-defense where we could probably do an entire hour-long episode and not cover every aspect of it.
Sure.
Um, the rules for not guilty by reason of insanity, they probably, like everything else, vary between jurisdictions. I'm going to give you the Indiana perspective because, of course, as we always mention, that's where I'm licensed. That's what I know. In Indiana, the defense of not guilty by reason of insanity is raised by filing a formal notice with the court. It's one of two defenses that need to be affirmatively pled. Most affirmative defenses, you can just spring them on the prosecutor at the last possible second, as long as there's what's referred to as a scintilla of evidence supporting the defense. Insanity requires a formal notification to the court that I am going to pursue the defense of not guilty by reason of insanity. In Indiana, what will happen is the court will appoint two doctors to examine the defendant. They will appoint a psychologist and they will appoint a psychiatrist, so a PhD and an MD. They will make an examination of the defendant to determine whether or not the defendant was first suffering from a mental disease or defect that is recognized in the DSM. That's the psychological Bible of mental health disorders. So the first thing they examine is whether or not this person was suffering from a mental disease or defect. The second thing that they will do is they will make a determination as to whether or not that mental disease or defect prevented the defendant from appreciating the wrongfulness of their actions at the time that it was committed. So, to throw it back to an earlier episode, if you'll recall from the Hot Dog Man episode, there was
Mhm.
an insanity defense that was raised in that, and the court appointed a psychologist and a psychiatrist, and they both found that Mr. Kajavak was suffering from narcissistic personality disorder, which is a recognized mental disease and defect, but
Mhm.
that mental disease or defect, the narcissistic personality disorder, did not prevent him from appreciating the wrongfulness of his actions at the time that they occurred. So that was kind of your floor mark as far as the insanity defense. Just because the court appointed doctors do not believe that a defendant is insane does not mean that a defendant who has raised this defense cannot continue to pursue it. The
Okay.
court will appoint its own expert witnesses as court officers. As a defendant, you can bring your own doctors in to testify about that. So you could have a trial where insanity is an issue, and the two court appointed doctors will say he's perfectly sane, but you can put your own witnesses as a defendant on to say, no, no, I've examined him. The reason the court appointed doctors are wrong is reason X, Y, and Z. The defendant is insane. On the flip side, if the court appointed doctors say that the defendant was insane, the prosecution actually can hire their own doctors as well to argue that those doctors are wrong and he's actually sane.
Mm.
What happens if you do proceed with the insanity trial? This is the other burden shifting affirmative defense that we have in the Indiana Code. The burden of production for the defense of insanity is the defendant is required to prove by preponderance of the evidence that he actually was insane. So under those circumstances, if the doctors both say he was insane, that makes it pretty easy for the defendant to say, no, see, he's totally insane and not guilty by reason of insanity.
Sure thing.
Um, it
Mhm.
is not a get out of jail free card. All of us are familiar with Batman thanks
Right.
to the multiple cartoons, multiple movies, things of that
Mhm.
nature. The running gag in Batman, of course, is that all of his villains are insane. They go
Mhm.
to Arkham Asylum, and that avoids being sent to actual prison. And of course, they escape from Arkham Asylum every 30 days because the
Right.
comics have to be printed. In Indiana, if you are found not guilty by reason of insanity, the court has a secondary aspect of the trial
Mhm.
where the determination is made as to whether or not the defendant represents a danger to himself or the community. And if they represent a danger to themselves or the community, what happens is they will be involuntarily committed to the state hospital at Logansport.
Okay.
And they stay there until they are deemed to be sane.
Mm.
That can be a very, very long time.
I was just thinking
Uh,
that. Hmm.
I have a client right now. We did do an insanity trial a number of years back. I want to say we did an insanity trial about 10 years ago. I'm gonna sit on that one because if we do a longer episode on insanity, I want to use that as effectively the
Sure.
case study to kind of work our way through that.
We'll keep our
He's
cards close to the vest.
exactly. He's actually he is unfortunately still at the state hospital in Logansport. It's been about 10 years.
Wow.
The offense that he would have been convicted of, the offense that he was charged with, if he had been convicted and if he had received the maximum sentence, he actually would be due for release right now. But because he is still considered to be insane by the court system, he's actually still in custody at Logansport. And
Wow.
there's not a lot that can really be done about that. It's up to the doctors to
Mhm.
make that declaration.
Man. So insanity really there I mean, there's a ton that goes into that.
Yeah,
And as we're sitting
absolutely.
here talking about it, Jack, I have a feeling we might be diving into this one a little deeper down the road for our audience. But a lot to go into the insanity one. Appreciate you, using some of those examples. This next one is one that makes me scratch my head a little bit. And this is the idea of a mistake of fact. What do we mean by mistake of fact, and how does that play a role in an affirmative defense?
Mistake of fact is it's not ignorance of the law being an excuse.
Okay.
I can certainly see that being the
Sure.
initial concept of like, well, I thought that ignorance of law is not an excuse. It's not an excuse. Just because you don't know it's against the law doesn't mean they're not going to bring you up on charges with it. Where mistake of fact comes up, and I have never seen one of these cases. I don't
Okay.
have a personal frame of reference to describe this. The best that I could provide to you would be a hypothetical style situation. So, for example, if if you're walking around with a sledgehammer slung over your back like John Henry, you're just kind of working on the rails, and someone comes up to you and says, "Hey, um, I really need for you to use your giant sledgehammer and break down the patio on my backyard. This is my house. This is my patio. I want you to break down this patio with your giant sledgehammer. Here's $100 to do that." If you were then to take your sledgehammer and bust up the patio, and the actual homeowner came home and said, "Wait a minute, what are you doing busting up my patio? This isn't her house. This is my house. You've just destroyed my property." That would be a defense that you would argue is a mistake of fact. You would be able to argue that you were acting under a reasonable belief that the person that represented that this was their home, um, it was in fact their home. You were acting again technically under legal authority. There's a little bit of an overlap there between legal authority and mistake of fact,
Mhm.
and that you had permission to actually do this work. It is probably of all of the affirmative defenses out there, I would say that mistake of fact is probably the rarest one that's going to pop up because it does involve an argument that you were completely unaware that
Right.
your actions were illegal or could be constituted
Yeah.
illegal. Um, and like I said, it's a little bit of an overlap with the legal authority issue. That's about the closest I can explain.
Right. Yeah.
That one I
No.
don't have frame of reference for.
Yeah, I would imagine mistake of fact, obviously a tougher one to see really play out in a courtroom. But let's move into the next one, which you and I had chatted about earlier before we pressed the record button that I know pops up a lot in drug cases, really. And that's this idea of duress. Talk to us about this affirmative, defense of duress.
Duress is an affirmative defense that argues that you committed a criminal act under the threat of imminent serious bodily injury either to yourself or to a third party. The idea is that effectively you were forced into breaking the law. And as you pointed out, it is very common in drug offenses, especially at higher levels or even federal level drug offenses. These are multi people operations, and Uh, Not everyone wants to be part of it, but no one wants to end up dead because they crossed a gang member.
Right. Right.
So what happens is these people are basically forced into being part of this drug trade or committing these drug crimes. You'll see that with they refer to them as mules, drug traffickers, or people who are carrying drugs from one place to another on behalf of a gang. They're being told that they'll be killed if they don't do that. We actually have handled a duress case in the past. We had a case in Shelby County last year where the situation involved our client, the defendant, was driving a vehicle. Her on again, off again love interest was in the passenger seat and was a regular bad guy, involved in drug trafficking, involved in other type of illegal activities. They got stopped by the police, and I can't remember off the top of my head what they were stopped for, whether it was a speeding offense, whether it was a turn signal violation. Either way, they ended up getting stopped. The passenger took a gun out of his pocket and quite literally shoved it down my client's pants and told her, "Hold this gun. Don't say anything about it, or I'll kill you." This is a pretty sizable problem for two reasons. One, of course, she's just being threatened with hold on to this gun or you're dead. The second is she had a prior felony conviction. And in fact, she had a prior felony burglary conviction because she was a drug addict. She was breaking into houses to feed her habit. Um, Burglary, though, represents what's referred to as a serious violent felony offense in the state of Indiana, and a serious violent felon who is found to be in possession of a firearm would be charged normally with a level 4 felony offense punishable by 2 to 12 years in prison. So the defense with that case was built around the concept that she only was in possession of this gun because it was forced on her and she was threatened with serious bodily injury if she didn't conceal the gun from the police. So that was the defense that we pursued with that case. I am pleased to say that it was successful. It was a successful defense at the end of the day. And that was one of those things that really help with that. But that's kind of what you're looking at with regards to the defense
Hmm.
argument. Duress argument is I would not have done this crime had I not been threatened or had my family
Right.
not been threatened. It's a very powerful defense. It is
Hmm.
behind self-defense. It is actually one of the stronger affirmative defenses that I believe that we have,
Hmm.
because it's very easy to imply and kind of get across to the jury that you were scared for your safety and that's why you
Right.
took these actions.
Right, right. I was just thinking the same thing. I would imagine this one kind of stacks up close to self-defense. Obviously, action wasn't taken, because of that feeling of duress,
Right.
but just
Right.
purely the claim of duress exists. So, all right, let's shift gears. The next one on the list, entrapment. Anybody close to criminal law or enjoys court shows or this and that, they've heard this term, but what does it mean in your eyes, Jack? This idea of entrapment in terms of the affirmative defense.
Entrapment is probably the most misunderstood affirmative defense in Indiana law. The
Hmm.
idea with entrapment is the argument, the affirmative defense is that the defendant would not have committed a criminal act had it not been for the urging and persuasion of law enforcement. Entrapment is not being presented the opportunity to commit a crime by law enforcement and then taking it. You have to actually show that, but for law enforcement's actions, you would not have committed a criminal offense. In fact, um, one of the things that the state can show to prove that entrapment isn't applicable is that the defendant was predisposed to actually commit this crime.
Hmm.
We get this. We used to back in the more Wild West days of the internet, when you had online prostitution sites like Backpage and things like that. You would see scrawled into the ads, you agree by contacting me that you are not affiliated with law enforcement and that violating this represents entrapment. It does not represent entrapment. If you were going to sell sex, you were going to do that whether or not the person that contacted you was a police officer or not, and that is against the law. So it is not an entrapment because you are already predisposed to commit that prostitution offense. Same situation if you sell to an undercover cop or you sell to a snitch. You were already predisposed to sell those drugs. That was something that was going to happen. You were going to sell those drugs to somebody. The fact that a snitch or an undercover officer gave you the opportunity to sell to them, which made it easier for them to arrest you, did not represent the crime of entrapment. I
Hmm.
have actually had, I actually have had an entrapment defense once. It was a misdemeanor. It was a misdemeanor case. It was a misdemeanor public indecency case. What happened is a law enforcement officer who I don't remember his name after all these years. He very clearly probably did something to piss the chief of police off, because he was sent to a park here in Indiana where they had been getting Indianapolis where they've been getting complaints about inappropriate behavior, and this cop zeroed in on my client and kept flirting with him, kept trying to get him to engage in gay sex acts. At one point in time, the officer actually grabbed my client's genitals and started fondling them. And at that point in time, that's when my client decides, like, oh, all right, well, I wasn't planning on this, but whatever. So let's go to town. And then he was arrested as soon as he went to go touch the officer's genitals, and it became an interesting trial situation because we argued. Unfortunately, this one did not work. This was one of the affirmative defense cases that we lost. The judge did not agree with our argument that there was no evidence that showed that the defendant was predisposed to committing sex acts in the park, but for the officer effectively creating a situation where a sex act was coerced. I still think they got that wrong.
Hmm.
But I suppose if I thought judges did their job right all the time, I wouldn't have a job. So there's that.
Very fair point. Gotcha. All right. So we hear you on entrapment. Moving to the next one is abandonment. Where does this come into play, Jack? Because I feel like this one might have some interesting, kind of protocols that go along with this.
Abandonment is one of those affirmative defenses. You're going to find that a little bit more commonly in a conspiracy style case. A
Mm,
conspiracy case is one where there's a little bit more in the way of active planning. There's a little bit more in the way of actual intent to commit a criminal act. So, for the abandonment defense to work, you have to argue that you completely and voluntarily abandon your effort at furthering a criminal action. So if, for example, you and your friends decide to rob a bank and your assigned role is the getaway driver, if you wake up and decide, you know what, I'm not going through with this. This seems ridiculous. This seems silly. This seems stupid, and you don't leave your house with your getaway car to go pick your buddies up to take them to the bank, that would be considered an abandonment. You have abandoned the conspiracy, you have abandoned the criminal activity. Even if your friends went through with robbing the bank on their own without you, they would not be able to come back and get you as part of the conspiracy because you abandoned your efforts in that. Now, the abandonment, as I said, has to be voluntary. And the law specifically holds that the abandonment is not involuntary. Sorry, the abandonment is not voluntary if circumstances that were not known to you when you started on your criminal effort increase the possibility of detection or apprehension, or if it made the crime more difficult. So, if you were to go to your local Walmart with the intention of shoplifting, and when you got to the Walmart, completely intending to get engaged in the shoplifting offense, and you found that there was a live security guard who is standing right there next to, let's say, the video game aisle, preventing people from shoplifting video games. That if you abandon the goal, then that would not necessarily constitute voluntary abandonment under the way Indiana interprets that law. And again,
Hmm.
this goes back to the issue of like where the conspiracy comes in, because if you're one part of the conspiracy, you
Okay.
abandoning your portion of it because, oh, it turns out there are more guards here. I guess I'm not going to go through with this, but your colleagues go through with it. You still went there with the concept of committing a criminal act. You did not
Right.
abandon it voluntarily. Another thing about the concept of how the abandonment statute works, if you just postpone your criminal actions, that's not considered to be abandonment. So
Okay.
if you go to the Walmart completely with the goal of trying to steal video games, and you see, okay, well, there's a guard here. I'll bet the guard's not here tomorrow. Let's come back tomorrow and steal video games. If you get arrested within the next 24 hours as part of that conspiracy to steal video games from Walmart, you haven't abandoned it. The fact that you didn't go through that day doesn't mean
Right.
you weren't planning on doing it.
No.
Also, don't steal video games from Walmart. It's
Yes.
a
Don't do
lot more expensive to hire an attorney than it is just pay for the video
it.
game.
Fair point. Fair point. Well said, Jack. We got two more in terms of these affirmative defenses. This is the final of the ninth that you mentioned are that are big in the state of Indiana as a whole. Let's go into the battered spouse syndrome.
Battered spouse syndrome is a newer affirmative defense. I believe that it's only about maybe 5 or 6 years old at this point in time. It straddles both the self-defense as well as the insanity defenses. The reason that this affirmative defense kind of got created is because people who would suffer the effects of post-traumatic stress disorder from abusive relationships, there's that old argument about like sometimes people just snap as a result of repeated abuse. So that doesn't necessarily excuse what would otherwise be a criminal act. Um, because post-traumatic stress disorder, it may not necessarily rise to the level of being unable to appreciate the wrongfulness of your actions most of the time, but in the heat of the moment, it's almost a form of temporary insanity is the easiest way of describing it. To proceed with a battered spouse syndrome affirmative defense, you have to notify the prosecutor's office at least 20 days before trial that you are going to be pursuing the battered spouse defense. It does not require the appointing of a psychologist and a psychiatrist by the court. If you want to bring in mental health professionals to testify on your behalf as the defendant, that would be on your dime. There are not going to be any court appointed experts who are going to testify on that. If you establish that you were suffering a mental disease or defect as a result of an abusive relationship, you can argue that that mental disease or defect made you incapable of appreciating the wrongfulness of your actions at the time of the alleged criminal
Hmm.
act. And if the argument is that it's some sort of battery related offense, like you shoot your abuser or something on those lines, or you beat your abuser with a baseball bat, um, that then shifts back to the self-defense concept. Like, okay, was the force that you used against this person proportional to the damage they had done to you previously? I've seen a couple of these. I have not worked on any of them myself, but it is one of those things that very heavily straddles that line. The thing that makes this aspect of the mental health issue different than a traditional insanity defense is if you are found to be not guilty by reason of battered spouse, which is not, again, it's not the technical term for it, but that's just the easiest way of describing it. You are not at risk of being involuntarily committed,
Mm.
even though there has been a legal finding that you were under a mental health issue, incapable of appreciating that your actions were wrong at the time that you committed them. Due to the unique nature of this particular defense, they will not involuntarily commit you for that. So you do have a little bit of a wider opportunity with it, but
Yeah.
it's in a very limited, narrow category
Hmm.
of defenses. Rightfully or wrongfully, jurors tend to take the opinion that, well, I would have left that situation, so why didn't they leave that situation?
Ah,
That makes it a little bit
good to know.
harder to sell with it.
Hmm.
Um, a lot of things as we're recording this right now. Of course, one of the major things that's going on in the media is the Johnny Depp Amber Heard defamation trial, and there's a
Right.
lot of discussion about the concept of intimate partner violence and domestic violence and how that does or doesn't play out and what actually happens with those. We are woefully bad at accurately relating that, accurately providing that message to people, and that can be a difficult defense to proceed forward with, simply because,
Sure.
again, there's the concept of I wouldn't put up with this, so
Mhm.
that person doesn't get away with it. So it's a complicated one.
Yeah, I can imagine. Yeah, sympathy, empathy, all those things
Right.
creeping into a juror's mind in those kind of moments. I hear you on the difficulty associated with that.
Mhm.
Jack, let's bring it home here. Final affirmative defense that you typically see, that 10th one, this idea of necessity. What are we talking about here?
Necessity is, as I said, this is the common law one. This one is not
Mhm.
statutory. It's just always been there. The idea is like sometimes you have to break the law because of reasons. The defense of necessity has a number of things that have to be shown beyond a reasonable doubt before you can claim the defense of necessity. You have to show that the criminal act is the result of an emergency. You have to show that there was no adequate alternative to committing the criminal act. You have to show that the harm caused by the criminal act was not disproportionate to the harm avoided. You have to show as the defendant that you had a good faith belief that to prevent the harm, you had to break the law. That belief has to have been objectively reasonable under the totality of the circumstances. And the defendant had to not substantially contribute to the creation of the emergency to get the argument of necessity. Um, I've seen this. I have actually had one necessity defense, and a very good friend of mine has had a necessity defense as well, both of which came in the context of driving.
Mm.
My friend's necessity defense involves someone who was charged with an operating while intoxicated offense, but his situation involved he was leaving a bar and he was being mugged. And it was one of those things where he managed to get enough separation between himself. He and his wife managed to get enough separation between themselves and the people that were threatening to rob them as they were leaving a bar. And they were able to get into their own car and drive off, where they were promptly stopped for speeding. And of course, they both smelled like distilleries. The argument they made was, it was necessary for us to do this because if we stayed there, we would have been stabbed. We would have been robbed. That's terrible. The harm that we created by acting in our drunk driving situation, that is not, that harm is not greater than the harm that we would have suffered had we stayed there to get robbed.
Right, right.
Um, that one, I would have to ask my friend. It's been a while since he and I talked about that one. I don't think that one worked for him. DUI cases are really, really hard. If there's any opportunity to hold someone responsible for voluntary intoxication, they're going to do it. So just,
Sure.
again, involuntary intoxication, okay. Voluntary intoxication, you sort of invited this on yourself.
Right, right.
My necessity defense was a little bit better. It was, again, in the context of a driving offense. One of the things that can happen in Indiana if you have too many moving violations is the State Bureau of Motor Vehicles can suspend your driving privileges as being a habitual traffic violator.
Oh,
That
wow.
would make it a felony for you to operate a vehicle while you were under those conditions.
Mhm.
My situation involved a defendant who was he worked for a trucking company. He was basically he was a loader onloader offloader.
Mhm.
His coworker, who was the one that was actually driving the truck, my client didn't have a CDL. He was not licensed to drive. It was very much one of those things like everyone knew he's here to help load and unload.
Mhm.
Um, the driver, the coworker, started having a medical emergency.
Oh,
And
wow.
I can't remember specifically what it was, but it's one of those things where it's very clearly, almost like a stroke situation, kind of like drifting off, nodding, sort of like just drifting into traffic.
Mhm.
Um, my client basically forced him to pull over, and due to the condition, got behind the wheel of the vehicle to drive him to a hospital.
Mhm.
And he got pulled over. He got pulled over by the state police because they were just on the lookout for big box trucks to get their quotas. I know a couple state troopers, they would be angry for me to say that, but they were totally getting their quotas. Pulled him over, realized that, oh, well, you're not supposed to be driving. You have a suspended license as a felony. Also, let's call an ambulance for this guy who's passed out in the driver's seat. So the coworker eventually got the medical attention that he needed.
Sure.
But when that case came up, that was one of the issues that we argued successfully. Is like, look, he's already in a vehicle.
Yeah.
Who knows how long it would take for an ambulance to get here? Something seriously wrong. This is a necessity. There was no adequate alternative. Who
Hmm.
knows how long it would take for an ambulance to get here? The
Right. And what
harm
was
to
the result of that?
that one was an acquittal. We did get them to acquit on that one. So that one worked out. That was a nice
Hmm.
result on that. We were very happy with the outcome on that one. Not happy that it got that far, but again,
Sure.
prosecutors don't allow me to make their charging decisions for them.
Yes, understandably so. Jack, we've covered the 10, affirmative defenses that you typically see throughout, today's day and age in criminal law and just court as a whole. I'm sure there's a contingency of people out there that are thinking, well, how does this differ from an alibi? Why do they not just have an alibi for some of these things? Could you, before we wrap up our episode today, kind of tie a knot for our audience and really split the difference between that what an affirmative defense is versus what a true alibi is, given a particular case.
Sure. An alibi is actually not an affirmative defense. That's the first thing that's a major difference between the two. An alibi is an argument of impossibility. You were arguing that it was impossible for me to have committed this crime because I was somewhere else. Alibi is not an affirmative defense because it doesn't change the burden. Again, remember what the state needs to prove beyond reasonable doubt to get a conviction is they need to prove that a crime happened and they need to prove that the person on trial for the crime was responsible for it. All of the affirmative defenses, it represents a change to what the state needs to prove because by pleading an affirmative defense, you're saying, yes, I did it, but here's my legal justification for why I did it. With an alibi, you're arguing, I did not do this. It legitimately was not me because I was across town on camera accepting an award for the mayor. That's an evidentiary issue. That's not an affirmative defense because you're not arguing that a crime didn't happen. You're just arguing that you were not the person who committed the crime. It's an actual innocent style defense.
Right.
So with regards to an alibi, what you're doing with the alibi defense is you're raising that as an issue. You're putting evidence on in your case in chief as the defendant, and the jury is able to examine that evidence and make the determination as to whether or not they believe the alibi defense and your witnesses as the defendant are credible enough to establish that, okay, no, this
Hmm.
defendant did not commit this crime. We cannot find this defendant guilty beyond a reasonable doubt.
Got it. Got it. But there is that fundamental difference where an affirmative defense, it is a true admission that the crime happened,
Correct.
but you're not legally responsible for the crime because of this defense. The alibi on the flip side, hey, I wasn't there. I had nothing to do
Exactly.
with it. So
Exactly.
yeah, you're maintaining that sense of being truly innocent. So
Right.
fundamental difference there. I'm sure there was a contingency of our audience today. There's scratching their head a little bit between trying to identify that difference. So I appreciate you clearing that up for us. And Jack, as we're kind of bringing our episode here to a head, we covered all these affirmative defenses. Clearly, you have experience in working with many of these. You have stories, obviously, to share with us. If anybody out there in our audience is maybe going through a tough time or a tough situation, and maybe they're interested in reaching out to you and your team to just talk about maybe a situation where an affirmative defense may come into play for them given maybe certain incidents that have transpired in their life, what would be the best way that somebody could reach out to you and your team at Razumich and Associates to just open up a dialogue?
As always, the best way to reach us is by telephone. Our telephone number here at the office is area code 317-983-5333. We do have operators that are answering our phone at all times. We take calls at 2 in the morning and someone answers that telephone. You talk to a live person, that message gets to the senior staff. And we do get the calls returned as quickly as we possibly can. That's always the easiest and best way to reach out to us if you have questions about this, if you have questions about another area of law that you're dealing with. Not every case does involve an affirmative defense. Just because a crime has some elements that might be covered by an affirmative defense. If that affirmative defense isn't there, you're not going to be able to use it. You can't just make them up out of whole cloth. But a good attorney, of course, is going to be able to provide you with an evaluation as to your options, as to the specific fact pattern and circumstances that you're dealing with, and can tell you whether or not any of those affirmative defenses or any other defenses are going to be applicable to your case.
Roger that. Well, Jack, look, I appreciate you carving some time out of your day to be with us here on the show to walk us through these different affirmative defenses, and looking forward to getting back together with you on the next one.
Absolutely.
Alrighty, thanks, Jack. And look, hey, we want to take one final moment, as always, and thank you guys, our audience, for jumping aboard and being with us here on the show today. If you enjoyed today's episode, maybe you took something away from it, do us a favor, hit that like button. Go ahead and subscribe to the show, whichever platform you're checking us out on today. And then, of course, share this information with any friends or family that you think would benefit from these types of discussions. You know, we've said it before, we'll say it again. We're taking the same types of, conversations, strategies, solutions that Jack is working on with his clients over at Razumich Associates, and we're bringing them right here to you on this show. And as you probably heard today, we've got some topics queued up for some future episodes that we couldn't really dive fully into today, maybe because we're going to address them in a future episode. And with all this future content coming, we'd hate to have you miss out on any of those beneficial episodes. So for Jack, I'm Ryan. We're going to go ahead and say so long, but we appreciate you being with us on today's installment of Closing Arguments.